this area and our lovely garden route. Welcome, and I see you've got a nice day there as well. Benoni, well done, Polokwane. It's stunning to have so many representatives and interested people over the country as part of our webinars. I'll shortly be sharing a PowerPoint with yourselves, but basically, just as an introduction, the webinar today will be presented by two of us. My colleague Stefan Hougaard, he's a litigant, a very good litigant. He will take the litigation aspect towards the second half of the webinar, and I will do the introduction to defects, to Voetstoots, where it fits in the first part of the webinar. Each of us will probably take approximately 20 minutes in our presentation, and then we will open the floor for questions as far as possible and as far as time permits. We will try definitely to stick to 1 hour strictly. Okay, so without more, I'm going to share my screen. Slideshow, sorry, from the beginning. Okay. So again, welcome to our seminar on latent defects and Voetstoots clauses and in agreements. I'm Marina Botha. I'm a director of STBB. I practice from our Cape Town office, and I love the law, and I'm very involved in property law, in compliance law, and maybe as an aside, also sectional title disputes. And I will be taking the first half of the webinar. My co-host is Stefan Hougaard. He's an admitted attorney of the High Court of South Africa. He's a director in our litigation and dispute resolution departments. And, you know, it is a specialist in general litigation, and that's why he will be speaking on our litigation aspects of this webinar today. Okay, just a few house rules. Please mute yourselves and remain muted throughout the webinar, but you're very, very welcome afterwards to raise questions and obviously unmute yourself for that purpose. But otherwise, you can post your comments and questions in the chat box, and we will try and address as many as possible there. We are unfortunately not making the slides available because it's part of our intellectual property. But generally, you can either contact myself or Stefan afterwards if you have questions, or just look at our brochures that's on our website. And then there's administrative queries, or you require feedback on any other aspect. Our marketing team is available for that, and their email is marketing1@stbb.co.za. And then just lastly, certification. We can only issue certificates to people who are online and in this meeting. So if someone watches the webinar afterwards, we obviously cannot issue a certificate to that person. And lastly, disclaimers. As you know, that's the thing that attorneys have to do. We present this course to the best of our knowledge, but it's not professional advice. And as Stefan will mention in his speech, the law is very fact specific. Every instance differs in as much as the facts differs. So this is a general background, and we invite you to seek professional advice formally if you need that. Okay, so let's start with the webinar itself. Voetstoots defects. I say here, blame it on the Romans, and for our starting point, we will just speak a little bit of Latin, and I promise we won't speak Latin after this slide. But in essence, what we inherited from the Roman law is that the seller has to provide the res vendita, this thing sold, to a purchaser in a condition that it is fit for the purpose for which it was bought. The Roman law also had an implied warranty against latent defects. That warranty either existed ex lege by operation of the law, so the law says it automatically applies, or ex contractu when the parties contracted in that regard. The problem with such a warranty against latent defects is the time period that attaches to it, because a seller could then ad infinitum be liable for latent defects that might arise. And that is a very unpractical and difficult position to be in. So it makes sense that there must be certain exclusions to that rule. And the one that we will spend some time on today is specifically the Voetstoots clause, whereby contractual arrangement between a seller and a buyer, they arrange to exclude that implied warranty against latent defects. Before I go further, just remember that latent defects in movables and immovable property is prevalent in our society, and there's loads of case law and litigation taking place with respect thereto. What we are going to concentrate on today is specifically those defects that are found or relate to property transactions, immovable property transactions, and in other words, based on a written agreement between the parties. If it's immovable or the movable property, there's agreement or there's no agreement, the rules change slightly. But today we concentrate on the immovable property and the agreement that parties reached in a written document. Okay. Voetstoots, we all know, means something has been, from the Dutch word storten, with their feet, in other words, pushed forward. You see, if you think of a barrel of grain and the two Romans, or the one Roman is selling it to another Roman, he pushes forward the barrel of grain, in that way passing ownership, but also saying, here it is, this is now your problem. Take it with its defects, latent and patent as is. From this, the next thing arises, because it means that the purchaser needs to be careful. The purchaser needs to apply his mind to what he's buying. And there is our last Latin word for the time being. I think Stefan will introduce a few more, but it's that principle of caveat emptor. In other words, buyer beware. It places a hefty, in my mind, obligation on a purchaser to make sure that he's happy with the condition of the item that he's buying. Similarly, if I have buying a house, I have a duty as a buyer, or an obligation, or a responsibility as a buyer, to make sure what the condition of the property is and that I'm happy to buy it in that condition. That obligation rests very heavily on a purchaser's shoulders. Okay, but now I am a purchaser. I've entered into a sale agreement. There's a Voetstoots clause in that sale agreement. When can I claim, or when does the law allow me to claim for defects? The law is very particular, and one has to get a picture of where this Voetstoots clause will fit in. It doesn't protect a seller if the seller is not aware. Doesn't protect the seller if he acted fraudulently or negligently in respect of facts that he knew existed in the property, defects. But what is a defect for purposes of the law? A defect, says our case law, is an abnormal characteristic that reasonable buyer would not expect to find in the circumstances of that purchase, of that transaction. It's objective. It's an abnormal characteristic that a reasonable buyer would not expect to find. It has to be material. If it's a negligible or small defect, it's not actionable in law, but our law says if it's substantial, it's material, unexpected, abnormal, and a buyer would not expect to find it in that transaction, then it's a type of defect that the law will pay attention to. Okay, but the purpose then of the Voetstoots clause is to get your seller away from that liability, liability ad infinitum for defects that may arise in the thing sold. But how far does it stretch? It only applies to the seller or helps a seller if he wasn't aware of the defect. I've listed two references to case law there. Both of them are fairly old. Van den Berg versus Coetzee related to a claim in respect of a defect in property where the seller was seized and he was represented in the transaction by an executor. And the court there said, listen, the executor, now acting as administrator of the deceased estate, couldn't and cannot know of the defect. It is not applicable in a situation like that. Haverside versus Hendricks, also an instance where a property was sold with a defect, that defect being there were no plans for the buildings on the property, but the seller himself at the time did not know that. And the court says then a claim based on a defect is not appropriate in such an instance. So it protects the seller where he was not aware of the defect, and if he did not act fraudulently or negligently. Stefan will tell you that there's loads of case law dealing with instances where claims based on latent defects are successful, but many where they are not successful because it's very difficult to prove that someone actually acted fraudulently or very negligently. And you might wonder, when can you say that someone was fraudulent or negligent? What is my seller's duty? Your seller's duty is essentially to advise a purchaser of defects that's within the seller's exclusive knowledge and which he knows the buyer is not aware of. The seller doesn't have a very general duty to advise the purchaser of defects, but if it's within his exclusive knowledge, and he knows that the purchaser is unaware thereof or is specifically inquiring about it, he has to disclose it. Things have changed slightly now that the property condition report has been made obligatory. So when there's a transaction that's facilitated by an estate agent, there must be a property condition report which is completed by a seller of property and in which he indicates whether certain deficiencies or defects on the property is extant or not. It does not change the obligation on the shoulders of a purchaser to inspect the property. That carve-out emptor principle remains, but it does give your purchaser a little bit of assistance in this process because he receives a report in which your current seller has indicated defects that he is aware of. It's important also in this context and emphasizing how important it is for a purchaser to do his due diligence before buying is the fact that the prescribed wording in the property condition report, as recorded in the Property Practitioners Act, says specifically the seller completed to the best of his or her knowledge, and the report does not constitute a warranty of any sorts. So it's just a slight extension of details of the property given to the buyer to help him make decisions, but the buyer remains the one in the transaction who needs to inspect what he is buying. Okay, let's go forward. Now my screen is up. So what does the law say? When is my defect latent? This remains, when will it consider it to be a latent defect? And this, as I've stressed throughout, is very, very important because of that principle of carve-out emptor. The buyer must beware. Now, the court says a defect is latent if it has the effect to impair the usefulness, utility of the thing sold, the property sold, and it is not discoverable on a reasonable inspection by an ordinary person. It's a very objective test, but it's not discoverable on a reasonable inspection by an ordinary person. And it renders the property unfit for the purpose for which it was acquired. In other words, it's very specific when the law will regard a problem that you have perhaps personally with a property that you don't like, when the law will say, yes, but this constitutes a defect. It has to be an impairment of the utility. It has to be not discoverable on a reasonable inspection, and it must render the property unfit for the purpose for which it was acquired. And from a litigation point of view, and again, this is Stefan's speciality, and he will touch on that, that defect to be actionable needs to be in existence at the time that the parties entered into the transaction. You will see that I've got two case references there. Again, it's just nice stories to tell, but regarding impairment and usefulness and not fit for the purpose for which it was acquired, in that Homedene Brickworks and Robert Construction matter, it was a transaction where Robert's Construction bought bricks from Homedene for purposes of building a house. The bricks were delivered. Robert's Construction started building, but it was soon realized by Robert's Construction that the bricks were deficient, and they had to break the walls that they had built already with those bricks and buy bricks from a different supplier and then use those. And a lot of discussion went about the defect in the bricks, but the court ultimately said that yes, there was a default, it impaired the usefulness thereof, it rendered it unfit for the use, and Homedene was right in obtaining other bricks from a different service provider and held Robert's Construction, Homedene, liable for the damages suffered. Again, Glasenhouse, I also think is quite interesting. That is where a property was sold. The seller, knowing that there was a cornice and a pediment and a sculpture in the property that was declared to be national monuments. The seller knew that. The seller also knew that the purchaser wanted to redevelop the property, and the purchaser had to expend a lot of money to comply with Heritage's requirements regarding the statues and the sculpture and the cornices. They had to take it out, build, and then put it in a special place. And the court said again, it was unfit for the purpose for which it was acquired. It's an impairment of usefulness and utility. It was withheld, but within the seller's knowledge. And yes, a claim for damages or the cost of the extra cost engaged was allowed. Okay, so we've now seen that Voetstoots, where it fits in is it comes from or as a result of our Roman Dutch law, which says, listen, if you give something, sell something to someone, there's an implied warranty that it is without defects. But the seller cannot forever remain liable for defects. In other words, he writes into an agreement, listen, I give the thing to you as it is, you take responsibility for any defects. And then we said that places a big onus on the shoulders of a buyer because the carve-out emptor principles applies. The buyer needs to inspect the item that he is buying. Voetstoots protects a purchaser, a seller, we said, only if the seller was not acting fraudulently, and obviously if he didn't know of the defect. If he knew of the defect, he would not necessarily be protected under the Voetstoots. He has an obligation to disclose that which he knows of and which he knows the seller, the purchaser, does not know. And again, we said a defect isn't a minor problem with a property. It's where there's a big problem. It's substantial material defect. In that scenario, enters the Consumer Protection Act, which became operational some 10 years ago, 8 to 10 years ago, and it has an impact on property transactions to a certain extent, but it doesn't have an impact on every property transaction. But there's two main places where you would, two main areas in usual property transactions where you would find that this act is applicable. The first is where the seller and the estate agent enters into a transaction with each other. The seller gives a mandate to the estate agent, and they then the estate agent then acts on the instruction of the seller. The trigger here is the fact that the estate agent is rendering estate agency services in the ordinary course of his business. Hence, for purposes of the Consumer Protection Act, the estate agent is a service provider, is a supplier, and hence the Consumer Protection Act applies, because the Consumer Protection Act deals with the position between suppliers of services and goods vis-a-vis an innocent consumer in the marketplace. So it's important also to know then in this context that where the seller and the agent engages with each other, it's in respect of the services that the agent is rendering. The agent never becomes the seller of the property. He doesn't own the property. He's not the seller of the property. But he renders estate agency services to the seller, and those services are the subject of Consumer Protection Act. In other words, the Act says it must be quality services. And if the seller doesn't receive quality services from the agent, there's certain remedies or redress that he can apply for. I've added in brackets there, and in that first point, and purchasers. Remember that estate agents as a supplier, and all suppliers for that matter, have certain responsibilities to the public at large, the way that they market, the quality of their marketing, the correctness, the accuracy of what they say. So in that regard, the estate agent also has a liability to the purchaser to render proper services. Then the second point where the Act can be applicable is a very contentious issue. Before I raise the contentions, if I said earlier, you have to be a supplier of a product to be to fall under the Consumer Protection Act. In other words, it's something that you do in the ordinary course of business. So a private seller and private buyer would not fall, the transaction that they conclude would not fall within the ambit of the Consumer Protection Act, because the private seller is not selling his property in the ordinary course of his business. He's not a seller of property. It is different if that seller of the property is a developer who does that on a continuous basis, or an investor who's got a large portfolio and sells and buys constantly, or a speculator in property, also where there's some constant movement. Then the seller, in those instances, will be a supplier, and hence the relationship between the seller and the purchaser is covered by the provisions of the Consumer Protection Act. What does that mean? In that instance, if the Consumer Protection Act applies, then there's certain lovely protection measures that the Act introduced. It says the product given to the purchaser must be safe, must be of a good quality, it must be fit for the purposes for which it was acquired in the circumstances of that transaction. And there's also an implied warranty of quality in respect of the item received. If you translate all of this to a property transaction, it places quite a heavy burden on your investor, your speculator, your developer, to give to the purchaser a item of substantial quality and of acceptable quality in the circumstances. In other words, my seller is allowed in those instances, if he falls under this Act, to say to a purchaser, listen, I'm selling the property to you. has been inhabited, it's second-hand, it's first-hand, I cannot warrant this, or I can warrant that, and that the purchaser knows what he's buying, then you can limit the liability under the Consumer Protection Act in those instances, provided your purchaser, your consumer, is advised of the detail of the transaction, advised of the condition of the property that he's buying. Okay. In respect of this Roman 2, where we speak of a seller in the course of business, like a developer, like investor, like a speculator in property, selling immovable property to a purchaser. There is a lot of legal discussion, opinion, and good reason to agree with that the Act can be interpreted or should be interpreted or will be interpreted by a court not to apply, in this instance, to transactions involving the sale of immovable property, and that it only applies in respect of movables. That is far from clear at present, and generally one works with the assumption that they would apply to protect both seller and purchaser, but just to advise you that in due course, hopefully there's a judgment awaiting publication or a matter on its way to court where this issue and this interpretation of the Consumer Protection Act will be challenged and we can get clarity on it. Again, I said to you, if the CPA applies vis-a-vis the agent must render quality services, and vis-a-vis the seller and purchaser in a sale transaction, the item sold, the home sold, the property sold must be good quality, safe, fit for the purpose for which it was provided, sold, and then there's an implied warranty of quality. Okay. Then let's, lastly, before I hand over to Stefan, look at where the Property Practitioners Act would fit into this scenario. This scenario being, I'm a seller of a property, I'm selling to a purchaser, it's immovable property, the transaction has a Voetstoots clause. In other words, it protects the seller if he did not know of the defect, and also if he didn't act fraudulently in not disclosing certain defects in the property. And there are defects that, and in the case of defects, obviously, that are material. If it's not material, it won't reach the court. In comes the Property Practitioners Act, which came into effect on 1 February 2022. And in that act, a new obligation was placed on the shoulders of state agents, and it said, when you enter into a transaction, when you facilitate a transaction between a seller and purchaser, you must make sure that the seller had completed an immovable property condition report and that it is received by the person who's buying the property. Obviously, this is only where a state agent facilitates the transaction. If there's no state agent involved, this provision wouldn't apply. So if it's strictly a private sale, seller and purchaser, the purchaser will not receive this report. As we've said also, the report is just that. It's an indication from the seller's side to his best knowledge what the defects in the property is. It's not a warranty, and it's specifically stated not to be a warranty, and specifically stated that the seller provides it as to the best of his knowledge. What to do then if it happens in certain circumstances that it is impossible for the estate agent to obtain this report? He has to provide it to the purchaser, but he cannot because the seller is overseas, the seller is deceased, the seller refuses to complete it. What happens then? Nothing much. The property practitioner, the estate agent, must simply just advise the purchaser that this is the form that should have been completed. I cannot obtain completion of it. In other words, check the items on the form and make sure you're happy to buy the property in the condition then that it is. The form is merely there to assist further detail, to assist the purchaser to get more detail about the property, but it does not take away the purchaser's obligation to do his own investigation. Lastly, and then to Stefan, if the Act says also that liability can follow on the shoulders of your estate agent if this report was not provided, and or if the content thereof or the fact that it cannot be provided was not disclosed to my purchaser. There's 2 points there. Either the agent is simply held liable because he did not complete the form and did not provide it to the parties, but there was no damages suffered by seller or purchaser, then the property practitioner's regulatory authority is likely to just impose a fine on that practitioner. However, the Act seems to go further and to state that the practitioner can also be held liable for other damages. For example, if the purchaser suffered damages because he did not receive the report. It's limited where this provision will apply simply because the law will presuppose that the purchaser had done his due diligence. It doesn't take away the fact that he has to do a due diligence. That the defect that he is complaining of would have been made known to him had he received that report, and otherwise that the seller wasn't fraudulent in not disclosing that defect. In those instances, there could be a claim that the purchaser can levy against the estate agent, but it's very, very limited. On this note, I'm going to hand over to Stefan, who will take you further into the tricky aspects of litigating on defects in property. Stefan, over to you.
Thank you, Marina. Let me just quickly share from my side. Okay. Is it not going? There we go. Okay, hi. Thanks, Marina, for that. Again, just quickly to introduce myself, I'm Stefan here in our Claremont branch. I'm a litigator or dispute resolution, or as I sometimes like to say, dispute avoidance department. Ultimately, I mean, we act for various parties when it comes to litigious matters where disputes rear their head in the context of today's discussion, and specifically to limit it to that of sale of immovable property. We act, or I act, for sellers often, or for purchasers, depending on the specific scenario, and then obviously to bring it into possible latent defects rearing its head. I've acted for sellers and purchasers in that regard, and the discussion will flow. I'm mindful of the time, so I'm not necessarily going to stop at every single point on the slides. I mean, the slides you'll see it's a more refined reiteration of what Marina has already said. She's already sketched the playground and how it will tie in enforcing your remedies and how to deal with it practically. And actually on that note, and I've already seen some very important questions being asked, which I've tried to respond to some. I think it is evident, or it actually will become clear, that the issue or the reality of latent defects and the Voetstoots clause, the law is not necessarily so difficult, in the sense that, as Marina has explained, it is quite simple, but practically how it plays out in practice, how it plays out in negotiating your agreement of sale, that becomes very tricky. And you guys have already asked quite important questions, and it actually just illustrates to me that I think there's more need to talk about the practical side. So I'm not necessarily going to spend so much time more on the legal side. But to start off, and Morena's already touched upon it, there was an important question asked, is that if the property is being inspected and there's a curtain in front of, let's say, a broken window, or another scenario that I've had before, there's a couch in front of I don't know, damaged carpet or something like that. And the question was, how will that tie in with the patency or latency of the defect? And that is actually a very important question because ultimately in our law, when a purchaser goes in to buy property or estate agents assist the purchaser to view it, things happen quickly. I mean, unfortunately, we're in that. I mean, and how our property market happens, generally, you don't take much time to inspect a property. And if you go back to the definition of patent latent defect, is that a latent defect is a defect that you cannot ascertain upon reasonable inspection. So to tie in that with the question about a defect behind a curtain is technically you can expect the purchaser to take a few extra steps in inspecting the property. And I would argue that that defect, albeit behind a curtain, is patent. Just another scenario, I've had it before where there was a room that was closed and the purchaser never asked to inspect and go into the room and there were certain defects. And come the dispute arising, it was argued, well, that's clearly a latent defect. And my argument was, no, it's not. You could have just asked and insisted to inspect. There was another person that raised the point about independent parties going into the property to inspect and it must be made law. Although I agree that it'll be great if it's made law, I don't think it will necessarily be made law. But of course, a purchaser can practically, in negotiating the agreement, insist on that. And actually, I don't know if you guys are aware, but this is actually catered for in American law where they've got that period of the property is in escrow, which it actually allows the purchaser now after it's been bought to, I wouldn't say live in the property, but to inspect it specifically for this reason. Now, the problem is in our law is that, and as Marina is also tied on, and I will get on it as well, is that the moment that agreement is signed, I want to almost say the die has been cast to an extent. So yeah, I think I'm just kind of sketching the playing field, how practically it 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 can become difficult. And as I'll illustrate, and yes, you have already raised a lot of questions about how practically you can mitigate issues that we are facing with um, regarding defects issues. So let me just quickly jump into the remedies in the case of latent defects. So I'm speaking out of this perspective of a purchaser. Of course, as I said, I also act on behalf of sellers. And given the context of the discussion, um, you will understand the perspective from the seller as well. But as I'm just kind of qualifying, I'm speaking on behalf of the purchaser here. So question is, what remedies um, will the purchaser have in the case of latent defects? So unfortunately, we're not done with the Latin terms just yet. We've got what we call the actia redebitoria. So actia just means action, that's your claim, and your actia quanti minoris. Now that stems from the Roman edilician actions when it comes to sale. So these are the two basic remedies that you have. So on the one side, actia redebitoria is, as the name suggests, it suggests restitution, a cancellation of the deal, since that the parties will return what was given to them. So the purchaser will obviously be able to insist on a restitution of the purchase price paid to the extent, of course, that it has been paid already. That obviously is a question to be answered as to where you are in the flow of your agreement of sale and obligations. And then again, depending on if the property's already been transferred, you can tender restitution of the property, return of the property. So it's quite important. And if you can see how I've illustrated with the bubbles around the specific remedies. So with the actia redebitoria, and if you, I mean, if with as Morena's already expressed and explained the requirements, and it now just translates into what you must prove in order to be successful with this remedy, in the sense that the defect must be substantial, in the sense that we're not talking here about minor defects. I mean, examples raised as a roof trusses sagging, or damp in the walls. Those are type of material defects, substantial defects that substantially impairs the property sold. Um, and it's important that the defect must be existed at the time of the sale. And there was a question, I can't remember if it was directly posed to me or in the group chat box, but it was quite an important question raised from the practicality of this element, in the sense that what happens if this latent defect becomes apparent after the agreement was signed and before registration of transfer. So obviously here it's at the time of the sale, the conclusion of the agreement is the important time period as to when this defect must exist. But obviously, considering what a latent defect is that it can sometimes only rear its head much later, after agreement was signed or even after registration. For instance, I'm thinking here a roof that's leaking. Granted, in Cape Town, that will probably only rear its head in the winter months. Now, that obviously begs the question, must the purchaser go stand with a hose on the roof? I mean, you can if you really want to, but that is ties in with the question that was asked, is that the defect must be prevalent at the time of the signature of the agreement. And yes, that obviously opens up a big practical question about how will you prove that? And as I will illustrate or explain a bit later, is that it's all fact specific, and you will have to assess the facts to see whether the defect was prevalent at the time of the sale. Again, as I'll say, is that generally this may involve expert evidence to tie in to say that, for instance, this defect was prevalent for, let's say, months, depending on, let's say, if it's damp, that's generally an easy one to prove, because the magnitude of the damp is not necessarily something that arises from one rainy season. But what I'm trying to illustrate is that, yes, it can be practically difficult to prove that the defect existed at the time of the sale, but that is an important element to prove. Of course, we were talking about latent defects here, so the defect must be latent, and the purchaser had to be unaware of the defect. And as I say, that's kind of implied with the term of latent defect. And then to tie in with the claim for restitution, there are two added elements where the purchaser has to prove that if the defect was known, he or she would not have purchased the property. Again, that obviously raises a practical question as to how you prove that. I actually don't want to go down that route because I'm just going to take up too much of time. That's, again, fact specific, that will have to be assessed on its own merits. And then obviously restitution, as I said, the claim is basically bringing an end to the transaction. So you must be in a position to actually return the money, or at least at this instance, if we're speaking from a perspective of the purchaser, it will be the property sold. And then, again, as it's illustrated on the slide, the actio quantum minoris, as I guess it suggests, is that there's a reduction in the price. You only have to prove the first four elements in that regard, and that will be calculation. As I've said there, it's a difference between the price actually paid for and what it is worth now with the defect being prevalent. I'm going to move on to the next slide. So those are the two primary remedies that you as a purchaser can enforce in circumstances where latent defects rear their head after the sale. Now, of course, we've been talking about Voetstoots. So Voetstoots clause, ultimately, as Marina said, it's a defense on the side of the seller, in the sense that it's a clause included into the written sale agreement where the liability for latent defects are excluded. But, and as Marina has pointed out, in order for the purchaser to rely on the aforesaid remedies, you obviously still have to prove the elements that we've just raised. The purchaser will go further, and it is practically a big hurdle to get across to prove the fraud element. I'm not necessarily going to reiterate everything that has been said there. I think I want to speak a bit more about the practical element and how difficult it is in practice to prove this element. And I'm sure that there are many questions running through your head as to how will you prove this? How will you prove the seller's fraudulent conduct in this regard? And I'm almost going to say to you that there really is no one recipe to it. It is fact specific, and it's something that you will have to assess depending on the type of defect. As I said earlier, is that when it comes to damp, and more often than not, it's just painted over when the property is sold. Those are the type of practical questions that you have to ask yourself in order to be able to prove this element. But obviously, it's important that the Voetstoots clause, which, barring the qualifications of the Consumer Protection Act, can be included in the agreement of sale, and the purchaser will have this hurdle of proving fraud in order to escape the application of the clause. Just to illustrate to you a bit, and I guess a bit anecdotally, I want to give you two examples that I wasn't necessarily involved in them firsthand, but of scenarios where the purchaser actually, I want to say, caught the seller out red-handed when it came to do, concealing, or at least not disclosing a latent defect. This was a story that I heard. Actually, my father-in-law told me the story where a purchaser bought a property was transferred, everything was great, and then obviously when you live in property, or the purchaser lived in property, realized that the roof was substantially defective. I'm not going to go into the technicalities of it. I think it was a southern suburbs property, and of course, it was a latent defect. And yes, as you know, there was a Voetstoots clause. The question is, how do you escape that? Obviously, the seller just raised that I'm not liable. There's a Voetstoots clause applicable here. In this specific instance, the purchaser, I think, went quite far to get contractors to quote on the remedial action. And I think he went to a Somerset West contractor. And lo and behold, this contractor said, no, but I quoted on this roof a few months ago for the exact same seller. Now, obviously, I think that's a golden pot at the end of the rainbow situation where the purchaser obviously had the evidence to prove that the seller knew about it. But I just love telling people that story just to kind of illustrate to you how difficult it can be for the purchaser to have to prove this element. And then just one other story. I was actually involved in this specific matter, which ultimately settled, but I acted for the purchaser. And here it was kind of the same situation where there were leaks in the roof and the roof was defective. It became apparent to the purchaser only after the property had been transferred and they moved into the house, and they saw a lot of buckets in the ceiling that was there to collect rainwater, which obviously implies leaks. That's one aspect that we argued the seller knew about it. Obviously, that still raises a question whether the buckets are not evidence of a patent defect, but let's not really go down that route. And then also it became apparent that the seller actually had gotten a quote for insurance purposes to fix the roof prior to the sale, which also illustrated the degree of knowledge and then the fact that it wasn't disclosed. Again, that matter became settled. So it was not necessarily before a court, but those are just two, I guess, practical stories in illustrating to you how a purchaser can prove knowledge on the part of the seller, but also how difficult it can be. If I can go on to, this is my last slide, when it comes to practically enforcing the remedies on the side of the purchaser. So this is a claim in the purchaser's hand. The purchaser will have to drive this process. It's a case of issuing a summons. We're not talking here about application proceedings, which is on affidavit. You actually have to issue summons and go to trial, sit in a witness box, and give oral evidence. Ultimately, in our court system, you've got the credibility, or at least the probability and viability of a party's claim is determined based on oral evidence. So as a purchaser, you will have to go through that process, which obviously comes with time, certain degree of anguish and acrimony, and of course, legal costs, unfortunately, to pursue your claim. So as I say there, it's generally revolves around factual disputes. Both parties will have different versions. You would have seen that the purchaser, especially in the context of a Voetstoots clause, it's quite a high hurdle to get across to prove the claim. So going on with my points, it's two different aspects, elements that you have to prove. It's the merit side of it, where you have to prove the existence of the defect, the fact that it was existed at the time the agreement was signed, whether the seller knew about it. We have gone through all the elements to prove, but that is the merits aspect to it, which is a factual question, but then you also come to the quantum side, which will generally involve expert evidence. And what I'm trying to illustrate with that is that when it comes to a reduction in the value of a property because of a latent defect, you will invariably need expert evidence to comment and give evidence to the court what the reduction in the value would be. And again, unfortunately, this all adds to legal costs, your cost in paying the expert, your cost in proving your claim. And then what I say there about a balance of probabilities is that in our system, court system, when it comes to a civil claim of this nature, the presiding officer will determine, how can I phrase, I always struggle in phrasing this properly, the most probable version on the evidence given and based on the credibility of the witnesses. The presiding officer, the judge, the magistrate, depending on where your claim is, will decide whether the purchaser or the seller's version is the most probable in the circumstance. And then to tie in with that, again, it's the onus of proof rests on the purchaser, but for, of course, the existence of the Voetstoots clause, which rests on the seller. Generally, if you've got a written sale agreement, which you are required to have in the context of selling immovable property, that is generally not a difficult element to prove. I mean, it's right, it's right there. But to illustrate that, unfortunately, everything rests on the purchaser's shoulders in order to prove the claim. So I do apologize. I may have been rushing through it, but I do think we're quite pressed for time. But I wanted to specifically leave time for Q&As. And if I can just add, you guys will have our contact details. If not, it will be shared because I've already said to some of you in direct messaging, some questions I think were quite good, but required a lot of delving in deeply. So you can definitely phone us whenever you need. And I see the chat box is exploding. So if anybody is willing to put on their cameras and their microphone, of course, please ask. That will actually assist us. But if I can just have a few seconds to just go through a few questions. Marina, I don't know if you've seen a few that you want to answer already.
Stefan, I've answered a few in the chat already, so maybe if there's any remaining questions, you can just unmute yourselves and ask.
I'm also going to go through a few to see if there are any good ones. But again, if we don't get your question, please phone. Definitely at no charge. I guess I have to add that as well.
Maybe I can just answer this last question. Professional property inspectors. It's a very valid question. And Stefan, maybe you want to unshare your screen.
Oh, sorry.
Valid question, and I think it would assist buyers quite a lot. I think why people don't make it an everyday occurrence is because of costs involved. That would be my gut reaction. Stefan.
Also, there's a sorry, I've unshared now. Sorry to interrupt. There's a good question about a time period. How long after the sale and registration of transfer can a claim be raised? That's a very good question. I don't know if it's answered yet, but that ties in with our law on prescription. So the general rule for prescription is a 3-year period. But now you're going to ask, when does that 3-year period start running? It is when the party in whose hands the claim is, and the purchaser, knew about all of the facts in order to sustain a cause of action. But let's just talk about the defect here, or reasonably ought to have known about it. I think I've phrased that correctly. And I think that is quite difficult when it actually comes in with latent defects, because again, depending on the defect, when will the purchaser really gain knowledge of it? But, and again, that's fact specific. But just to tie in with your question, it is a 3-year period, and it's not after registration. It's after the agreement was signed, but of course, registration ties in and implies when occupation is given. So there's obviously also a question of early occupation, but that all just ties in as to when the purchaser reasonably ought to have gained knowledge of these defects. If I'm
Stefan, you're breaking up.
I just also add on the top. Can you guys hear me now? Hello?
Okay, we can hear you.
Sorry, I think that's the most common statement in virtual meetings. Can you hear me now? Where I just wanted to say that again, I think the topic of early occupation is definitely raises a lot of practical questions in the sense that, and I guess commercially, and again, this has happened to me a lot, is that does a seller to give early occupation to a purchase because then sometimes latent defects are actually discovered. But then on the converse, that's also something that a purchaser can insist on for this specific reason. Yeah, sorry, that was all flowing from the question as to how long do you have time to claim. And that's prescription is a very important element. Any other questions? Again, if we don't get to all of your questions,
Stefan, I have a question.
Yes.
Hi, if you can hear me, Morena, can you hear me? It's Stephen de Stadler.
Yes.
Hi, how's it? Sorry, maybe a fairly arbitrary question, but just something going back to latent and patent. The concept of animals, working on the wild coast, on the whale coast rather, obviously baboons, sometimes penguins are mentioned in the context of some of our properties. Can this ever be perceived as a latent defect in the circumstances where the client sees the house at a time when the baboon colony is behaving in Pringle, as opposed to, when they're not behaving, if you know what I'm saying?
Yeah, that's a loaded question. In this, that's by no means an easy one to answer. I guess it also depends on for you act. If I act for the seller, I would say no, no, it's not. It's not a. Sorry, that
Sure.
I'm just. The thing is, unfortunately, I'm trying to illustrate that it's not an easy answer, and to be honest, you can argue for both parties. What I would actually argue in this instance, and I guess this just illustrates that law is not black and white. I would say that it's not necessarily a defect relating to the property. Yes, it may be a fact or a circumstance relating to the area, which then begs the question, does the seller have a duty to disclose it? I would even go so far as to say no, because I mean, you're talking about Pringle Bay, Betty's Bay, I mean, going up all the way to Franskral, I guess, baboons prevalent. I mean, I don't necessarily think it is a defect in relation to the property. It may be a fact relating to the property. Now you're going to ask me that what's the difference? Again, maybe we can have this discussion offline, but I don't think it will be a patent or a latent defect. And then it just begs the question, to what extent does the seller have a duty to disclose that? I would also go so far as to say, given the area, I don't necessarily think I mean, that should be common knowledge. Again, let's just say that you caught me off guard with a question, and you're more than welcome to phone me.
No, thanks. No, that was my take as well, but I just wanted to, it's just something which came up in the conversation. So thank you for that. I appreciate it.
Okay, cool.
I've got a question, Maddie. So if the seller and buyer agreed to have the Voetstoots clause removed, then what would go in place of that, or what would the agreement be?
If I can answer that, I'm gonna say rather answer it in a negative, or not negative, in the sense that the agreement will be a standard sale agreement, but without the Voetstoots clause. So it's the seller does not have the protection that the Voetstoots clause would offer. So it the seller would be able to be held liable for the latent defects, as I've explained, the specific remedies, and the seller just won't have the protection of the Voetstoots clause to rely on, which means that in turn, the purchaser does not have that extra level of fraud to prove. As we've shown and illustrated, I think there's a key element then of fraud and knowledge, where if it wasn't there, then the seller would obviously be able to be held liable on the remedies if you accept or that all the elements have been proven. So I hope that answers your question. Any other questions, guys? I think we've reached our hour limit here.
I would have a short question about that window, that broken window. It's just
Yes.
too minor, right?
Well, maybe not, but I think as I said earlier, the problem is that it's probably patent in any event, in the sense that it was, assuming it was there at the time the agreement was signed. Obviously, if the broken window occurred after the agreement was signed, then the seller would be able to be held liable, because the seller is obliged to deliver the property as sold. So that just kind of adds to it. I hope that answers your question.
Not really, but it's okay.
Well, you're welcome to phone me. I believe our details have been shared.
Okay.
Okay, then Stefan, if you're happy, I say thank you to everybody for joining us. And as Stefan said, you're welcome to raise further questions with ourselves. It's very difficult to give broad answers. Practically when it comes to litigation and to dealing with parties who want to fight each other, it's the details of that transaction, and yeah, one needs to discuss that with your legal practitioner at that time, or beforehand, preferably. Okay, thank you then. Stefan, is that
Yep.
good to go?
As I said, yep, you guys know where to get us. You're welcome to phone me. Okay, guys, thank you very much. Enjoy your day.
Thank you.
Okay.
Bye.
Bye.
Bye.